Okay guys, welcome to another tutorial session of LB200, the law of obligation. And in this video, I will give you some of the the example of how to do the obligation exam in the part of Ajahn Junavich, which will based on the first question of the previous year final examination. Here, there's the question one that Mr. K has been losing a lot of money in his business, had a lot of debt with many creditors. And this is scenario, Mr. K already know that he himself do not have enough property to pay the whole debt as well, and he still caused this kind of scenario in ABC up. The first scenario here is that Mr. K sold his gold watch to Mr. A at the price of 100,000, which is lower than market price. But Mr. A did not know about Mr. K debts and financial situation, and later Mr. A gave such gold watch to Mr. B as a gift. And the fact appeared that Mr. B knew about Mr. K debt and financial situation. Second scenario or scenario B is that Mr. K allowed Mr. C to borrow his motorcycle and return it at the fixed time, but Mr. C did not do it. Later the motorcycle was destroyed by Mr. D, but Mr. D gave a new motorcycle of the same model to Mr. C in replacing the damage, but Mr. K did not pay any attention to claim anything from this incident at all. The scenario says that Mr. K, while talking on the phone, verbally granted a release of obligation to Mr. E. And the obligation is that a written loan contract that Mr. E borrowed the money in the amount of 90,000 baht. And also that loan contract already been due for 3 months. And Mr. E knows about Mr. K debt and financial situation. Now Mr. H, who is a creditor of Mr. K, come to you asking for the legal advice to be used the legal approach to be used for the benefit of controlling and protecting Mr. K property. So, let's look at the first scenario here. The scenario A, Mr. K sold his gold watch to Mr. A at the price of 100,000 baht, which is lower than the regular market price. What is the section relevant to this fact? First thing to consider when there's something like sold the watch under the regular market price is something that prejudice creditor. So when there's something that prejudice creditor regarding the Juristic Act, the section you should think of is section 237. That is the cancellation of Juristic Act that prejudice the creditor. However, all of the conditions must be satisfied. First condition is that it must be the Juristic Act. Here it is a sale contract. And the subject of the Juristic Act is the property. In this case, obviously, it is the gold watch. And the Juristic Act should prejudice the creditor. In this case, it's prejudice because why? Because Mr. K knew that he did not have enough property to pay the whole debt and he still sold it under the market price. Then it obviously prejudiced the creditor, who is Mr. H in this case. But the last two elements is about the mental elements here. First element is that Mr. K here must know that it will prejudice his creditor, and obviously he knows because the price is lower than regular. But Mr. A, who is the third party here, if in the case that it is not a gratuitous Juristic Act, aka it is not free, then the knowledge of the third party or Mr. A in this case is required, but seems like Mr. A know nothing about Mr. K debt and financial situation. Therefore, Mr. A, who is in good faith here, we can interpret that he do not know of the situation. And he was protected. The Juristic Act cannot be cancelled by section 237. And later, even Mr. A gave a gold watch to Mr. B as a gift, and Mr. B know Mr. K debt and financial situation. That is not the point related to the cancellation anymore. Because of now, Mr. A already received the ownership over the property through the sale contract, according to section 458, and he has right to dispose the property, including to give away, according to section 1336 here. Now, the scenario B is that Mr. K allowed Mr. C to borrow his motorcycle and return it at the fixed time. When we talk about a fixed time here, the section we should pick up is section 204. Because of if it is the fixed time of performing obligation and the debtor cannot or fail to comply, fail to perform in obligation without any benefit from section 205, or he cannot avail himself, he is automatically be in default without any warning. And here, Mr. C did not return the motorcycle at a fixed time. Therefore, he is debtor in default according to section 204. Later, Mr. C carefully parked the borrowed motorcycle, and the motorcycle was hit and destroyed by a truck driven negligently by Mr. D here. Now, the fact that the motorcycle was destroyed by a truck driven negligently by Mr. D means that the destruction or the impossibility to return the motorcycle, this one, is not occurred by Mr. C's fault. However, because of Mr. C is the debtor in default, section 217 say that he is liable for any damage, even it is not his fault here. So, Mr. C is still liable for damage. And then, we can see the fact that Mr. D admit his fault, so he give a new motorcycle of the same model with the same price to Mr. C in replacing the damaged motorcycle. This means that the new motorcycle is a substitution by section 226 because of it is a property that Mr. D give it in replace of the damaged property. Here, the elaboration may be made more by section 226 paragraph 2 such that the real subrogation, a property is substitute for another property in the same juristic position as the previous one, is called real subrogation. And in this case, because of the old motorcycle that was already been destroyed is in the juristic position such that Mr. C is liable and Mr. C have to return it, right? And even it was hit, Mr. C still liable for this one, for this fact. So it means that by the fact that Mr. C is liable, it made the destroyed motorcycle and the new motorcycle that Mr. C acquired as substitution be in the same juristic position. Therefore, it is a real subrogation here. And Mr. K here can exercise the real subrogation through section 228 such that in consequence of the circumstance and the debtor here is Mr. C acquire a substitute for a claim for compensation for the object owned, which Mr. C is still be the debtor here. He still own the return of the motorcycle because he's the debtor in default here. So, section 228 say that the creditor can claim for compensation himself. In this case, I mean, section 228 mean that Mr. K can ask Mr. C to return the new motorcycle that he received from Mr. D as the substitution for the impossibility occurred. Even it is not Mr. C's fault, but it is Mr. C is occurred during Mr. C's debtor in default according to section 217. So here, it is real subrogation and the issue of exercising the claim that Mr. K can exercise through section 228. But by the fact that Mr. K did not pay any attention to claim compensation, here, we may advise Mr. H to use section 233 because of here the obligation already become due. Why? Because of Mr. C already liable, right? And it is already past the due date that he have to return. And I mean Mr. K also have the claim against the debtor who is Mr. C here to return the new motorcycle he received as substitution, but he refused to do so, and it will prejudice the creditor on Mr. H here because Mr. K have not sufficient property. So, Mr. H here may exercise section 233 to exercise the claim under his name on behalf of Mr. K directly to claim that Mr. C must return the motorcycle, the substitution one, to Mr. K. Next, scenario C. Mr. K talking on the phone verbally granted a release of obligation to Mr. E, but the obligation is written loan contract. The section relevant here is the validity of the release. And section 340 say that the release will be valid in the case of the obligation is in written form. In this case, the obligation or the loan contract was evidenced by written, right? Because it's written loan contract. The release is valid only if it is in written as well. In this case, because of the fact that Mr. K talking on the phone verbally granted a release of obligation to Mr. E, but the fact is that the contract is written, right? The source of obligation is written contract. It means that there is no release at all. Obligation here is not extinguished. Not only that, Mr. E who borrowed the amount of 90,000 baht here, the obligation of Mr. E to Mr. K already been due for 3 months. Here, it is the fact between Mr. E and Mr. K such that Mr. E is debtor in default, therefore is Mr. K claim the specific performance here. He can also claim for the interest by section 224 of 5%. But it seems like the fact here Mr. K granted the release verbally, even the release is not valid, so the obligation is not extinguished. But it seems like Mr. K don't want to exercise his claim against Mr. E at all. And when Mr. K, who is the debtor to Mr. H, refused to exercise the claim against his debtor on Mr. E, and is prejudiced the creditor here, Mr. H can use section 233 to exercise the claim under his own name on behalf of the debtor or Mr. K here to claim that Mr. E must return money of 90,000 baht to Mr. K. Also, Mr. H here can claim for interest as well. He can demand interest that Mr. E should return interest to Mr. K as well. But now, there's another 2 section that is possible to do so. It is the special case in exercising the claim, which is section 234. Section 234 is the special situation in the procedural part that in this procedural, Mr. H here, who is the debtor of Mr. K, must summon Mr. K to be in the court, in the action, to force Mr. E here to pay off the debt. And in this case, it should be done comply to section 234, such that Mr. H must summon Mr. K, right, to force Mr. E to pay. But on behalf of, he should do that on behalf of Mr. K. However, Mr. H could receive the money from the loan contract between Mr. E and Mr. K directly by applying section 235 such that the creditor may exercise a claim belonging to the debtor for the whole amount due to the debtor without regard to the amount due to him. But the defendant may satisfy something like in the section. But the meaning is that Mr. H is able to exercise a claim belonging to the whole amount due to Mr. K, which is 90,000, and he is able to claim those 90,000 baht directly from Mr. E, but he just cannot obtain more than what is due to him. So it means he cannot obtain more than what Mr. K is in debt to him. So in this case, to elaborate again, it's not only that Mr. H can exercise the claim under his name on behalf of the debtor under section 233. Mr. H can also use the procedural part of section 234 and 235, which fall under the special case as already been described here. So this is the way to answer the obligation law question in this final examination.